Good morning, everybody. My name is Linda Hyder. I'm the Chief Operating Officer for the South East London Chamber of Commerce. Welcome to this webinar. We have got quite a few people on the call and still waiting for others. So I just thought I would just wait a minute for some more to join us. But this, just to let everybody know, this is actually going to be recorded, this webinar. And it should be later on, it will be actually posted on our website. So I'm just going to talk about just a bit about the speaker background, who is Michael Pope from Grant Saw. So Michael Pope, this is a solicitor at Grant Saw Solicitors LLP. He brings over 4 decades of legal expertise, having commenced his career with Wolseley Morris and Kennedy Solicitors in 1983, quite a long time, where he became a partner in 1987. In 2008, he founded Lawbridge Solicitors, now part of Grant Saw Solicitors LLP. His comprehensive understanding of employment law makes him well qualified to discuss the recent Employment Rights Bill. So I'm going to hand over now to Michael, who will start the presentation. And just to remind everybody, it is being recorded. So good morning, Michael. Over to you.
Good morning, Linda. Thank you very much for that. And good morning, everybody. Welcome to Grant Saw. Thanks for joining us to listen to a discussion about the Employment Rights Bill. My colleague Michael is going to deal with our slides, and I'm just going to pull those up.
Oh, just while they're putting the slides up, just to remind everybody that after Michael's presentation, there will be an opportunity to answer all your questions then. The presentation will be roughly around 30 minutes or so. Thank you.
Okay, I think we're nearly ready to go with the slides. Can it? Which one is it?
Bear with me.
Okay. I tell you what, whilst Michael's getting that set up, I'll start talking about the subject matter of the Employment Rights Act. The Employment Rights Bill. I've left my notes in another room since I thought that the presentation would come up in front of you, so I might just have to excuse myself for 1 minute. Is it coming? Yep. I think we're nearly there. Ah, here we are. Right.
Right, is that being shared though? That's the,
I'll let you know when we see it.
That'll be good.
right.
Okay. All right.
You can see it with the slides on the side.
Go on to the next one then.
Excellent.
Okay. You can see that. That's very
yes,
good.
lovely.
Okay. All right. Well, sorry about that false start. So we're going to talk about the Employment Rights Bill, and I just want to put it into context, tell you a little bit about the background to how we've got here. So in 2021, Labour kicked off their plans for the new employment landscape with a green paper called A New Deal for Working People. That came out with some quite radical proposals, but by the sort of early part of this year, when the election was in train, they rolled back from a lot of those more radical proposals, and in the manifesto there is a slimmed down version of what Labour originally said it would do. What they said they would do, though, at that point was that they would introduce the employment bill within 100 days of taking office, and they succeeded with that. Next slide. So by the No, in fact, it was probably the last day on which they could have published the bill within the 100 days they got there. It's a large piece of legislation, 158 pages of legislation, 198 clauses, quite a lot of detail in there. And on top of all of that, there's 7 schedules. And there is quite a lot of this legislation which is going to come in under statutory instruments. That means that in the bill itself, the Secretary of State for Employment will be given the authority to lay a statutory instrument before Parliament. There'll be no debate at that point, and that instrument will then come into effect as part of the legislation. That will deal with things like time limits and so on for certain parts of the operation of the legislation. So the government is consulting. It's already started the consultation process, but most of it is going to take place next year before the majority implementation comes into effect in 2026. What they've said about the unfair dismissal legislation, and that's a very important part of what we're going to be talking about, the new day one rights, that's not going to come into effect until autumn 2026 at the earliest. So we'll talk about that. Now, in the context of Labour's plans for this legislation, there is an extremely interesting and helpful document which was published last month, and it's called Next Steps to Make Work Pay. And what it does is it tells you what the government's view is on many of the provisions in the bill which will be subject to debate and on which decisions need to be made. And frankly, with the size of the government's majority, it's almost certain that the government's preferences are likely to take preference over other bodies and stakeholders in the legislation. So that gives us a guide, and I'll mention as we go along what the government's preferences are in relation to some of these issues. What that document also mentions is some of the things I mentioned right at the beginning about Labour's original plans for the restructuring of the employment landscape. These are things that are not in the bill, but I mentioned them really just to sort of put the whole thing into context, which is where Labour would like to be. And some of this will probably take place in the current Parliament. Some of it might be sort of pushed over into the next Parliament if Labour's successful at the next election. These are things like a review of parental leave, not before time because parental leave is an utter disaster, a review of carers' leave, surveillance technologies in the workplace, and the consultation process. I think Labour is particularly interested in getting the unions more involved in those processes, those negotiations, certainly obviously in unionized, but not necessarily entirely unionized workplaces. The single worker status, that's the big one really. That is the Labour plan to simplify the status of people at work. We've got 3 categories at the moment: employee, worker, and independent contractor. And Labour is talking about merging the employee and the worker into one status. That would take an awful lot of planning, and it's not on. It was in the original plan, but it's not in this bill. So it's not going to happen in the next few years, and it's probably one that will be planned for and implemented some way down the line in the next Parliament. A written contract for self-employed, that's interesting. That presumably would be something like the written terms and conditions of employment that employees and workers have to have. I've done an awful lot of contracts for self-employed people over the years. They're all different. And the idea of streamlining that and putting in some basic terms is interesting. A review of TUPE, a review of health and safety laws. The idea of raising collective grievances, that's very interesting. Grievances, obviously at the moment, are things brought by aggrieved individuals, but this sort of looks like a halfway house between a trade union dispute and an individual grievance. It's not clear what they've got in mind there, but it might very well be, you know, a workplace process. I nearly said protest, but maybe that's what it might be. So that's one to look out for, I suppose. The Fair Work Agency, that I think is probably going to happen sooner or later, and it's a body that's going to deal with probably the low-level employment claims. At the moment, for things like unpaid wages and so on, you have to go to an employment tribunal. It's a long-ish process, and really, why do you need an employment judge and all the process of an employment tribunal to determine that someone wasn't paid £50 or something when they should have been? That is going to be a little bit more like an ombudsman process where, you know, one of the staff internally will determine the outcome. I don't know precisely what claims that's going to cover, but it might simplify things to some degree, and not before time, really. So there are some specialist areas in the bill. I've noted, in fact, that we've got a number of people from a care sector agency. I'm afraid I'm not going to talk specifically about that part of the bill that deals with that today. It's fairly technical, and there's a lot of detail to be added. It's a negotiating body that is coming into effect for that particular sector. And the same thing is happening with education support workers. Obviously not teachers, because they have their own negotiating body, but there is quite a lot of the bill that's directed towards those two processes. The other thing to say just quickly is that the trade union legislation that the Conservative Party has introduced since 2010 is been repealed wholesale. So basically the trade union movement has got effectively what it wants through the Labour government, and all of the most recent trade union reforms have been thrown out. So what I will look at then is, first of all, this day one right, unfair dismissal, the ending of fire and rehire. That's another important and significant development. The ending of exploitative 0 hours contracts. The word exploitative is in there for a reason, because it's not about the abolition of 0 hours contracts wholesale, unlike what I'll be telling you about fire and rehire, which is probably now gone, or will be gone when the bill is enacted. Protection from sexual harassment, and in fact, more broadly, protection from harassment of any particular kind, if it's on the grounds of a protected characteristic. That will entail new processes, I think, and something possibly people could be working on more or less now. Flexible working, changes coming to that, but it's not what the government promised, which they said it would be the default process for everybody. And the Daily Mail headline that people would have the right to demand a 4-day week was coming. That's not what's happening. In fact, it's a very limited change to flexible working. Bereavement leave, a lot of businesses, of course, and charities and so on, have discretionary bereavement leave, but there's only at the moment statutory bereavement leave in relation to parents of children under the age of 18. There are a few changes for pregnancy and maternity leave, could be significant. The statutory sick pay scheme is changing. That is quite an important thing. It's going to impact on a lot of people. Gender pay and disability reporting only impacts on very large businesses, so I won't say much about that. Collective redundancy consultation, another union-driven change, and a union-driven change on the written statement of particulars of employment. So just mention all of those. So just to put the whole thing into context, I'm going to just sort of outline the position in relation to the law at the moment in connection with each one of these areas and then say how it's going to change. So you probably know at the moment there's a 2-year qualifying period for unfair dismissal. And that means that until that period is served, effectively an employer has a free hand, other than obviously the requirement to give notice under the contract, except in relation to claims that don't require a qualifying period of service. And the most important of all of those is the discrimination. So when advising clients on terminating employment within the 2-year period, one is always on the lookout for the possibility that the employee might say that the termination is in some way linked to discrimination. That's really the only restraint. And apart from that, employers, as I say, have had a very free hand to, effectively, I suppose you might think of it as a 2-year probationary period, because there's been this freedom from the law of unfair dismissal if you wanted to terminate the employment within that time. So after 2 years, the full unfair dismissal process applies, and there are 5 potentially fair reasons to dismiss an employee. You probably know about each of those: conduct, capability or qualifications, redundancy, some other substantial reason, and illegality. I'm going to mention each of those in context because they're each, in fact, differently affected by what's going to be coming in the new legislation. On top, of course, of those grounds for dismissal, you have to treat, the employer must act reasonably in treating that reason as a sufficient reason to dismiss the employee. So that involves the need for a reasonable investigation, a fair hearing, consideration of the whole picture, the employee's position, the length of service, the current warnings, and so on. What is called equity and the substantial merits of the case. There must be a right of appeal. And in addition, in relation to redundancy, and in fact, in relation to some business reorganizations, there are additional procedures, consultation processes, selection procedures, and so on. Probably people are very familiar with that, but they are going to be impacted. So I'll explain how that's going to work. So just to put into context the process, if an employee wants to bring a claim for unfair dismissal, if they're qualified to do so, then they must notify ACAS within 3 months of the dismissal, and they must start the ACAS early conciliation process. That works well on the whole. ACAS are very good at mediating and trying to resolve issues, and it works quite a lot of the time. If it doesn't succeed, then the individual has to bring a claim to the employment tribunal within about a month of the completion of that early conciliation process. The claim that is then brought, and if successful, will lead to, first of all, effectively a redundancy payment, calculated in the same way as a redundancy payment, with a weekly rate, which is capped at £700 a week if the employee earns more, multiplied by the length of service and the age of the employee. And on top of that, a compensatory award, which basically works on loss, so that if an employee has lost money because they've been out of work for a period, then they will succeed, subject to a number of requirements to show that they've made appropriate efforts to try and find the alternative employment. They will receive compensation. In fact, it's up to a year's gross annual pay, but that if that exceeds £115,000, then it's capped at that level. The process, of course, is a time-consuming one, and from both sides, there's the uncertainty of it, the effort that has to go into it, and the cost. And the regime is effectively a cost-free regime. There's no fee for the employee to pay to start the process, and it's unlikely that the employer will get its cost at the end of the process, even if the employee's claim has been pretty weak from the very outset. bit more effort made these days by the tribunals to weed those cases out, but unfortunately the idea is that the whole thing must run its course. So we come on to the new regime, and as I say, it's autumn 2026 when we're expecting it to come into effect. What does that mean for people at the moment? Well, it means that somebody who is employed now, just starting work now, will have to wait 2 years to bring a claim for unfair dismissal. Someone employed in a year's time will then be running down to 1 year and they'll be qualified to do it. The government says that 9 million people are impacted by this. It's an enormous number. So to that extent, it's a major change. It's a major change to the landscape. But the question really is, what is the process actually going to involve? So we'll have a look at that. The first thing to say is that it's only going to apply to people who've actually started work. So anyone who's got a job offer, which they've accepted, but which is withdrawn, will not be able to bring a claim unless the reason that it was withdrawn is for a prohibited reason, such as discrimination. Now, the government is going to effectively develop a system of what I'm going to call unfair dismissal light, which is going to be new procedures for a period of the employment. At the moment, the question is that what's that period going to be? The government in the paper that I mentioned, the Next Steps paper, says it wants 9 months, and so it's likely to be 9 months. Also, the government, there's nowhere in the bill is the word probationary or statutory probationary period used. It's called initial period of employment. And so whether we'll all having to get used to calling it initial period of employment or IPE, I don't know. I imagine the word probation will hang around for a while. So what we don't know is what the scheme is going to look like. What we do know is that it's going to apply effectively only to conduct and capability cases. Redundancy is going to remain as it is. And that's logical and understandable because it's still going to require what the mechanics of it are at the moment. That's the consultation process, the selection process, and so on. That's the redundancy happening within the 9-month IPE, if I can call it that, the initial period of employment. So if a person is, if an employer gives notice within this period, but the employment doesn't terminate until this 9-month period or whatever it is terminated, the process will proceed under the new unfair dismissal light scheme, so that an employer could, as the bill presently stands, give notice at the end close to the end of the 9-month period. The notice then expires, let's say 3 months later. It'll still be covered, as things presently stand, it'll still be covered by the new regime. What we don't know is what the compensation is going to be in relation to this. I've just mentioned what the compensation regime is at the moment, but there's no certainty that it's going to be anything of the kind. There are a lot of employment, or quite a few employment claims, where if you're successful, you get no more than 2 or 4 weeks' pay. And whether the government will be persuaded to limit the amount of compensation along those lines, at the moment it isn't clear. So what might it be? Well, there are 3 real possibilities. The one is procedural only. In other words, that a bit like flexible working or something like that, where all the employer's got to do is to give its reasons and put those in a certain form. And unless it fails to do that in the right way, possibly with a sort of a reasonableness test attached to it, then that would be it. Something and nothing, really. The second possibility is a reasonable test in the full sense. So there would be a a monitoring process during the probationary period, and a warning, presumably, that things were not going as intended, so that it could be demonstrated that the employee had awareness of the fact that this was coming. Or you could have a situation where a dismissal within this period was deemed to be fair, unless it was shown to be completely unreasonable. That's a sort of a perversity test. It's a sort of no reasonable employer would terminate in those circumstances unless the employee could get to that level of argument and succeed in persuading a tribunal that that was the case. Then the dismissal would be fair. This is within, as I say, within this 9-month unfair dismissal-like period. After that, the full process would obviously come back into play. What will be required would be the requirement to give written reasons. Funnily enough, at the moment, you have to have a 2-year qualifying period before an employer is obliged to give the person written reasons for their dismissal. Well, that's going, might already have gone. But obviously it doesn't make sense to have to wait 2 years for written reasons if you're being dismissed within 9 months. What is certain is that there's going to be a lot of legislation, or a lot of litigation on this, because there's an awful lot of law on how unfair dismissal works, how the tests should be applied in practice and all of that. So, we can look forward to years of the Employment Appeal Tribunal, Court of Appeal, and possibly even the Supreme Court developing the law once the government's decided what it is. What should you do now? Well, I think the answer is probably not a lot, because I think we are too far back from what we're going to be having to cope with in 2 years' time, that it's very difficult to say exactly what you should do. I mean, fairly obviously, this is going to lead to, or it would be wise to have a review of your recruitment procedures and your probationary management procedures. Those things are obviously part and parcel of good practice in any event, and they are likely to be, one way or the other, the key to controlling the situation when the day one right comes in. I think there might be yet another upsurge in settlement agreements, possibly even a tariff. It may be that, if these things, if a relationship breaks down within a short period of the commencement of employment, to avoid, if the process is anything other than fairly benign, to avoid that process, an employer will possibly offer, I don't know what it might be, but a small amount of money to encourage the employee to leave, and there'd need be a settlement agreement to make that binding. Whether that will sort of encourage people to hop from one job to another and get themselves dismissed and pick up settlement agreements along the way, one shudders to think. The ACAS conciliation process, I'm assuming, will apply to the new regime, and if it does, then things will be funneled through that. And ACAS really are very good at sorting things out, but it's also likely to lead to some kind of resolution through some kind of financial payment. So I think we'll see more of that, and I think we'll see more staff engaged through agencies, although of course there's a cost implication of that for employers to work out. So we'll see how that goes. So that's the day one right on unfair dismissal. Just have a quick look at how we're doing for time. Running through quickly, ending fire and rehire. As I said earlier, this is the end. It's thought by lawyers to be the end of fire and rehire to all intents and purposes. And it works at the moment on the basis of a fair dismissal through some other substantial reason, one of the 5 reasons I gave. So at the moment, a person needs a 2-year qualifying period. And what the employer has to do is to show a reason which justifies the termination and dismissal of the employee and their re-engagement. And it has to go through a fair process, and that involves consultation with the staff, telling them why it's the proposal is required. It might be a reduction in pay, it might be a change of hours, it might be some other change to terms. And at the end of that process, the employer gives notice. So the notice period is served, the old terms remain in place until that's done, and then a new contract is offered. If the employee doesn't take the new contract, then they are treated as dismissed, and they can bring an unfair dismissal claim, but they will have to show that there's been a failure on the employer's part to establish its case, that it was necessary to put in the change in the first place, and or that it failed to consult properly, got about it the wrong way. There is actually a requirement for this, technical requirement, because it's a technical redundancy to terminate a contract in this way. And if that happens and there are more than 19 people affected in the business in a period of 90 days, then a statutory consultation process has to take place. Very much, well, it's the same as the statutory redundancy consultation. It's exactly the same thing. That has to run for a period of 30 days before the first termination can take place. It must be conducted in good faith and with a view to reaching agreement. And if it isn't done properly, then there is quite a sizable potential claim, which is 90 days uncapped pay for everybody who has been affected by that. So that's the law at the moment. What's happening? Well, fire and rehire is becoming effectively an automatically unfair dismissal once the new act is implemented. And of course, with the day one right for unfair dismissal, then everybody who is employed in the business and who's subject to that treatment would automatically be unfairly dismissed if the impact of the fire and rehire process affected them. It works on the basis that the employer, if the employer seeks to vary the contract and the employee does not agree with that, then that is an automatically unfair dismissal. Or it could be that the employer employs another person under a varied contract to carry out the same duties. So in other words, it puts in a replacement. That too will be an automatically unfair dismissal. There's a limited exception, which is to save a business in dire financial circumstances. There isn't at the moment clarity about how that's going to work, but it's pretty clear that that is going to be an absolute last resort situation. And so, as I say, now effectively fire and rehire is becoming unlawful. And that is problematic for employers because it's going to affect harmonization of terms and other legitimate and necessary requirements to change the nature of the employment process within the business. So really watch this space on how that develops. 0 hours contracts. The government says there are over 1 million people working on 0 hours contracts. So again, a lot of people affected by this. At the moment, not much law. There was in 2015 a ban on the use of exclusivity clauses, and any action taken in that respect could lead to an automatically unfair dismissal. But otherwise, they're perfectly lawful and legal. And what we've got in the bill at the moment is very difficult to follow and understand. There's 11 pages of the bill devoted to this. It's very much like the working time regulations and the national minimum wage legislation. And there's more legislation that's going to come on top of whatever's in the bill through statutory instruments and so on. It replaces the Workers' Predictable Terms and Conditions Act of last year, which the Conservative government implemented, which they enacted but never implemented, I should say, so never come into effect. The new legislation is going to have 3 key rights, which I'll just run you through in a minute. There is an anti-avoidance provision, which is that it's not just 0 hours contracts that are going to be caught by this, but it's going to be minimum hours contracts. That's to avoid people putting a half an hour of work as a guarantee into a contract and saying, well, it's not a 0 hours contract. But it's obviously going to be a low level, because otherwise it'll start to encroach on genuine part-time work. And so what this is looking at is 7 or 8 hours, probably as the limit for the minimum hours process. The agency workers are covered, and this is very problematic, but again, it's an anti-avoidance provision. So the 3 rights, the first right is guaranteed hours. So instead of having a 0 hours contract, an employer will have to guarantee a certain number of hours. And how is that done? Well, it's done through a reference period, and at the moment it's not clear what the reference period is going to be, but the most likely is a period of 12 weeks, which is what works for 0 hours contracts and variable hours contracts when you come to calculate holiday pay. But that's not certain. But if it is implemented, and whatever period really is implemented, it won't affect genuine temporary workers, because they won't get to the 12-week period. So they won't be offered, there'll be 0 hours workers, but won't be entitled to be offered a new contract. It'll work on the basis of a new contract, which must be offered to the 0 hours worker. Not clear when that must be done, presumably before the end of the existing assignment. And there will then be a period during which the employee can accept that new contract. Not clear how long that will be either. What we do know, of course, is that the terms cannot be less favourable than the terms of the contract during the reference period. So the next guaranteed right is a notice of shift, and this impacts on anyone whose shift pattern is not known in advance. It could be someone who's not a 0 hours worker, but they don't have regular advance information of their shifts. The employer must give reasonable notice of the shift. Now, we don't know what that's going to be, and we do know that it's not going to be a deemed reasonable period. So it's not going to be set in stone as 3 days or whatever. It's going to be a presumed period, and that means that the government will give guidance, but ultimately the employer will be entitled to say, well, I'm entitled to give a shorter period of notice in the circumstances. The presumption has been displaced. Obviously, this will be problematic for employers in terms of short-term requirement, somebody ill or something of that kind. Moving on to the next and the third of these changes, and that is the notice of cancellation of a shift. Same thing, it's a presumed period of what will be reasonable notice. If the shift is cancelled within that period, then what's likely to happen is that there'll probably be a sliding scale. So if the period is 3 days and it's cancelled in 2 days, then it may be that 50% of the shift sum will be payable or something of that kind, but we don't have the detail just at the moment. Problematic in the case of agencies are brought into this because they won't have the funds to pay for cancelled shifts unless they themselves have been paid for it. So it's ultimately going to be a question of the hirer, I think, being responsible for that. Moving on, and just checking the time. Yeah, I want to leave some time for questions. You're probably all familiar with the fact that at the end of October, new law came in on sexual harassment that requires what's called the protective duty to take reasonable steps to prevent sexual harassment in the workplace. It doesn't require an employer to take all reasonable steps, but just reasonable steps. And I'll explain that in a bit more detail in a minute because it's relevant to the way the legislation is going to work. What it does is it entitles the Equality and Human Rights Commission to investigate if they get complaints which suggest that an employer is not complying with its protective duty, and it can fine companies, employers, unlimited fines for that. But also, if a claim for sexual harassment is brought to the Employment Tribunal and the protective duty has not been followed, then the Employment Tribunal can increase the whole award by up to 25%. But this is not a direct claim brought by the employee in the first instance. So what the government is planning is to increase this protective duty to all reasonable steps, and that is a high bar. Effectively, it means looking at what the employee did and saying, the employer did, I'm sorry, and saying, well, what else could they have done? And if they find that the employer could have done something else, then presumably all reasonable steps haven't been complied with. Government is going to introduce a new form of claim for discrimination, which is third-party harassment. That was in the law, goes back to an old case involving the comedian Bernard Manning, who was involved in some kind of performance for a client, for a business, and he abused, I think it was the waitresses and people in the audience, to the point that they brought claims, and the government following that enacted a third party the right for a claim against a third party for harassment on a protected ground, obviously, but that was then abolished. That's coming back, and the protective duty is going to be made a direct claim. So an employee will, in relation to not just sexual harassment, but to any form of prohibited characteristic harassment, is going to be able to bring a claim direct to the Employment Tribunal. So I won't run through the full detail of this. It's what would amount to the right thing to do in relation to preparing to show that an employer had complied with its duty to do all that's necessary to protect itself, to protect its staff from sexual harassment. And as I say, it's going to be other forms of harassment, I think, within the next 2 years. There is a lot of guidance and help. The Equality and Human Rights Commission has issued a technical guidance note on this, and just this morning, in fact, they've come out with an 8-step process that has to be followed. And if you follow that, it's effectively a code of practice. Then it will give an employer a strong argument to say it's doing all it can, but it's demanding requirement. Things like training. Then it needs to be frequent. There's been a recent case with training that was 2 years old was considered to be insufficient. Training of managers, particularly important. You see a lot of managers dealing with sexual harassment cases who don't really understand, what it is that the law requires of them. So plenty there to be getting on with, and that's something employers could be doing at the moment, I think. Flexible working, that, as I said, really is a bit of a damp squib. It isn't what the government said it was going to do, which is the default, being the default position for all workers. It's really not changed very much. It's still subject to this limit of compensation of up to 8 weeks pay. What's changing is that the government in the bill is going to enact some form of additional requirements. The current process of going through the 8 reasons, legitimate reasons for refusing the flexible working request, and require that that's put in writing, which remarkably it isn't required at the moment, and to justify it in a more reasonable way. So they'll have to give their reasonableness assessment, but it's not really changed very much as things presently stand. It might be a subject of an attack in the House of Lords or from some of Labour's own members in the House of Commons, so it might be beefed up, but at the moment it isn't much. The grounds for refusal, I won't go through all of those. They aren't changing, same as it is now. So I think that is, in fact, yep, that's the same thing. So bereavement, very, very quickly, the government is going to introduce a statutory bereavement entitlement for everybody. If you just go on to the next slide, Michael, that issue there is going to be the definition of the relationship of the bereaved to the employee. In other words, putting it bluntly, who has to die for them to be entitled. It's going to be 1 week. There is going to be a statutory level of pay, as there is at the moment for bereaved parents of a child. They get 2 weeks. There are going to be, at the moment, really just tinkering changes to parental leave and paternity leave by simply abolishing the 26-week qualifying period for those. The government certainly needs to do more on these family-friendly rights to make them, so parental leave in particular, to make it workable. Very quickly, the position on maternity and pregnancy protection is being beefed up. At the moment, the protection applies, as you probably know, only to a woman returning from maternity leave in relation to redundancy. She must have priority over a potentially suitable alternative post. This is going to, by the look of it, now extend to all forms, if you go on to the next slide, Michael, to all forms of dismissal of a woman in probably a 6-month period after the termination, after the end of the maternity leave period. So in other words, a woman who is returning from work for a 6-month period will be unsackable. That's the government's plan on maternity protection. Statutory sick pay, this is straightforward, but going to affect an awful lot of people. So if you go on to the next slide, the proposal is that the 3-day waiting period is going to be abolished. So from day one, of sickness, the employee will be entitled to be paid. The lower earnings level is going to go. The government will set the new rates, as it does at the moment, by a statutory instrument, and employees earning less than that will be paid a percentage of their week's pay. It's not clear what that percentage is going to be, maybe 60%, 80%, something like that, but we'll have to wait and see. The action plans for the larger employers, I'm not going to talk about that really, largely because I don't know much about it. It's not at the moment a well-developed plan, but it's going to affect the gender pay gap reporting, and also an important feature, of course, lawyers have been arguing for years about menopause and whether it's a disability, so there's going to be guidance on that. Quickly, for collective redundancy, there was a famous case called the Woolworths case, where for the purpose of calculating the number of employees who are to be made redundant by a business, do you look at the individual branches, or do you look at the business as a whole? Because Woolworths were doing a redundancy process affecting a number of stores, and I think it was eventually the European Court decided that it's the individual unit where the redundancy is taking place that has to be looked at, not the business as a whole. It's about the definition of what is the establishment at which the redundancies are taking place. So it was a store-by-store definition, and of course that undermined the consultation process, certainly so far as the unions were concerned, because their members were spread across a number of branches. That's been the law for, I don't know, 25 years. That's going, as we'll see on the next slide. The word single establishment is going to be abolished. So the fact is that the whole of the enterprise will be taken into account, unless it's broken up into different companies, because it's the employer, the company employer, that is the respondent to these calculations. So if you had, for example, two or three different employers within the same company, within the same group, employing different numbers of people, then that would in fact technically avoid the numbers totting up for consultation purposes. As I say, it's union driven because they obviously want to ensure that consultation is available as widely as possible. And the last thing to say is that there's one change to the standard written statement of particulars of employment that everyone has to give out when an employee starts work, and that is that it now must require, doesn't at the moment require, but we'll see in the next slide, the last slide, that it does, it will be necessary for those particulars of employment so that the employee has the right to join a trade union. Doesn't apply only to businesses where there is a recognised trade union for collective bargaining purposes. It applies across the board. That's coming in, I would imagine, 2 years' time, might come in a lot sooner. That's it, really. I think I've just about got time for 10 minutes of questions. So hand back, I think, to Linda for that.
Oh, thank you very much, Michael. That certainly raised lots of questions. You know, I've got about 4 or 5 written down, but I think that we'll ask the people that are on the webinar, would you like them to raise their hand or just to sort of unmute and then ask the question?
Whichever's easier, maybe unmute and just start talking.
Okay, right. So over to those on the webinar who have a question for Michael. If you'd like to unmute and then just start talking, please. Well, nobody's done it, so can I start with my questions then?
Okay.
You mentioned a stricter probationary period. Does that mean that, because a lot of organisations use 6 months, so are you saying that they're going to probably reduce their probation period or put strings attached of what must be covered in that period?
I think it's the content of what the probationary process entails. So I think it's more active engagement. Very often the probationary period is just served out, and then obviously somebody at the end of that writes a letter saying that the probationary period's been passed. This is, you know, going to involve more active engagement with the probationary process. So there would be more meetings, more assessments, more evidence in writing, more warning. So, you know, you would maybe in a 6-month probationary or a 9-month probationary period, you might have regular 2 or 3 sessions where the line manager, maybe the line manager's manager, someone like that would get involved to see how the probation was developing. Because if ultimately there is a decision to dismiss the employee with the new regime, it may be necessary to show reasonableness.
Oh, right. Yeah.
That there was an issue. It may not be a high standard. I think that's probably what we're saying about unfair dismissal light. It may be the paperwork would be enough. It may be, look, we've had 3 meetings. At the end of meeting number 1, we said, you're not doing X, Y, and Z, and you need to improve. At the end of meeting 2, we said same thing, and so on. So I think what I meant is a more invasive.
Okay.
That's not the right word, but more engaged probationary process. Yes.
Yes, because I wasn't sure whether, because within the probationary period, it's usually, you know, if they don't come up to scratch, then you sort of say, well, within the probationary period, then we're not going to continue with a permanent contract. But it seems like that you have to give more reasons and go through the process.
Exactly. It doesn't stop you from, I don't think it's going to mean going through the whole of the probationary period if the evidence is there that it's not working.
Yeah.
You know,
okay.
Just getting that evidence together.
Thank you. I was going to ask about, you know, sometimes people use a restructure to get rid of somebody in the business. So is that, you talked about the change in the restructure. So if they are somebody, so if they sort of did a restructure and then afterwards they ask somebody to just cover that person's job without changing the job title,
Mm.
is that something that would you could go for unfair dismissal? And is it just a 3-month period?
Yes, well, it depends really on what's happening. If what's
Yeah.
happening is it's like a fire and rehire,
Yeah.
the reason that the person is being moved out is to put in place a cheaper replacement. That's, I think, what you're asking. That's what the law is going
Yeah.
to be. That you can't bring in cheaper if it's exactly the same duties. I mean, you're going to get all sorts of arguments about, the restructure by definition means there's got to be some change in the way the job is done. That's,
Yeah.
you have the same thing with redundancy. Redundancy works on the basis of, what does the job actually entail? So you'd have to have a job analysis of some kind. But yeah, I mean, I think if you replace somebody effectively like for like and pay them less, then
Yeah.
the person who has been moved out has been automatically unfairly dismissed. There's no argument about it.
No.
It's an unfair dismissal, and it's just about the compensation. What we don't know is what the compensation regime is going to be. It might be the full thing, in which case they might have lost a year's money.
Yes.
Might be a slimmed down version where they're paid a smaller amount. We don't know yet.
Okay, thank you. Is there a question from, yes, I'm going to let Edouard.
Yeah, that's right. I'm an HR consultant, so thank you so much for the presentation, Michael. What I wanted to ask in particular, I've read that it's going to take about, they say, 5 billion for business to implement the changes. So I wanted to ask the question, then, is the Employment Rights Bill good for business then?
Oh, you're asking the wrong person. I can't really comment on that. I mean, that's a political question to some degree. It's a question of economics. Well, it will cost. These things always cost a lot of money. Against that, of course, the government would say, well, but there are significant benefits in it for huge numbers of people. And ultimately, it might actually save money because it may mean that things work more efficiently than they have done in the past. People are more engaged. The whole process works better. So you get these figures thrown out. There have been big changes in the employment landscape before, and we're all still here. And I think this isn't necessarily quite as seismic as it was thought to be originally. As I said, a lot of it's been watered down, and by the time this all gets through Parliament, particularly with limited compensation payments, I don't think we're not going to have hundreds of people queuing up outside the employment tribunals to get in and get their claims heard. But we don't know for certain. It just depends on how it evolves as legislation, and hopefully it'll be good for business at the end of the day. But I'll be careful about saying that too loudly because there will be a number of businesses that will not be comfortable with it, and but they'll adapt and develop their processes and get their heads around it, and we'll all carry on.
Okay, thank you so much for that.
Pleasure.
Thank you, Michael. I know we haven't got long. Could I just quickly, just one quick question? You talked about the bereavement period
Yes.
of being paid for 1 week.
Yes.
I think you said there's going to be a definition of the relationship, because if people could keep saying, oh, my relative, an auntie died, and get another week off, because you get a lot of people that play the system.
Yes.
So I was just wondering, is a definition going to be issued?
Yes, definition is going to have to be issued.
Yeah.
And you're quite right. It's going to have to be sort of fairly tight. Otherwise, there will be people possibly misusing that. Which would be
definitely
sad,
will
really.
be.
Yeah, it'd be a bit.
Yeah.
It's unpleasant to think that.
Okay.
But,
okay, thank you. Can I just before we wrap up, well, 2 things. If people have got questions that they didn't feel they could ask on screen, if they sent the question in to us, someone has got their hand up. I'll answer them. If they sent a question to us, then we could pass on to you perhaps to answer.
Certainly, yes. No
Um,
problem.
and I was just going to, well, we've got one more question. I was just going to quickly say we've got 3 events coming up. I was just going to promote, we've got another webinar in 2 weeks on the 20th of November of how to develop and implement a green travel plan. We've got some Bromley office drinks with Thackeray Williams in partnership with Barclays on the 21st of November, and that's an evening event. And we've got the Lewisham Lincoln drink on the 27th of November at the Everest Inn at Blackheath. But all these details can be found on the Chamber website. So I'm just going to go back to Cien El Tara, who had their hand up. Would you like to ask your question, please?
Good morning, and thank you for the time. And thank you, Michael, for having been through that with us.
Thank you.
I just wanted to ask, because as you can see, we're in the care sector, and especially the 0 hour thing you were
Yes.
talking about. Because of the complexities surrounding
Yes.
the timing for especially home care,
Yes.
it appears it's going to be a bit more complicated for us
Yes.
if we have to, if the 0 hours contract is completely taken out of the table, because
Yes.
you can't be paying for services not rendered, and because of that, how do you think we might be able to navigate that change that is being proposed?
Well, that's a very good question. 0 hours contracts are not being taken out of the picture altogether. It's just that the nature of the changes are, they're significant, and they are going to impact on agencies. I think the answer is simply we don't know yet, and this is one of the major, I think, things that the government's going to have to get to grips with during the consultation process is how our agencies going to be involved in this. And certainly, contracts between the agencies and the hirers are going to have to be changed, I think, to accommodate it. But to be truthful with you, I think at the moment it's too early to say. I can understand why you're asking the question and concerned about it, but there isn't. I don't think there's enough at the moment information to know exactly how it will work. So it is something to watch out for. Your industry, sector information will obviously be very switched on to this, and no doubt there'll be debates in Parliament and House of Lords, and consultation. I mean, this is all going out to consultation next year, so you might want to watch out for that. Write to the Department of Employment and ask to be included in that process, so that you get the regular information as this develops, so you keep yourself fully informed, and take advice as necessary.
Thank you so much once again.
Thank you.
Well, thank you, everybody. Thank you again, Michael, for your excellent presentation. So I'm sure we've all learned a lot. I know I have, and it's probably, as I say, sparked more questions. So thank you again for your time. And I'd just like to close the webinar.
Thank you. Thanks, Linda.
Thank you.
Bye.
Thank you. Bye-bye.